Hello once again. I would like to welcome you all in this IP Foundation course and patent search training or webinar organized by the ITSO office of BISU-Candijay campus. So I was given a task to talk about the overview of intellectual property rights, and later on we will have some demonstration on the overview of patent search. So first we will talk about the design. There are two kinds of design process. We have design process 1 and we also have design process 2. So the design process 1 is a problem solving approach wherein ideas turn into concrete solutions. So it involves study on the behavior of the target market, also the characteristics of the environment, the time scale, and the best strategies for the implementation. So before we can see any of the products in the market, it comes first in the mind of an inventor or someone who has an idea to have this product to provide solutions. Okay, so it is coming from ideas and turned into a concrete solution. So here in this picture, we can see the process of the design process 1. Okay, this is the part of the design process 1. First, the inventors have this design research. Okay, after that we have this, they analyze what they have searched on this different, for example, patent. And then they will have this conceptual sketch. Okay, so they will think this specific conceptual sketch of their invention. And then after having this conceptual sketch, they will have these detailed drawings. And then there is a mock-up. And after that, we have this prototyping. And then we will test our invention, for example, industrial design. And then after that, we will present it to some panel, okay, or some experts or someone who is in the business field. So this is the design process 1. Okay, and we also have this design process number 2. The design process 2 is the continuation of the problem-solving approach of design process 1, wherein concrete solutions are to be brought into the market. So it involves protection of the intellectual property generated from the study, also market introduction of express ideas, evaluations, and evaluation of the technology. Again, for the design process 1, it is only like a preparation. Okay, you have this idea to create your own products or have this invention. Okay, you need to have some search, you need to analyze, and you have some conceptual sketch of your design of your invention, and then you have this detailed, you have a specific detail of the parts of your invention, and you have this mock-up and prototyping. Okay, like you will just form a design, and then you will test your invention. After that, you will present for prior comments, suggestions, and improvements. And after that, if you are already have this revision as part of the design process too, you have the revision of the design after the presentation, and after that you have a IP protection or IPR. You need to protect your intellectual property, and then you will introduce that into the market, and you will also have some evaluation, and then you have this design research. So first we will have to discuss the different terms in order for us to fully understand what we are going to talk about in the other topics. First is the property. What is the property? Property means anything that can come under the right of ownership and be subject of contract. So it represents more than the things that a person owns, and it includes the right to secure and dispose of them, according to Tanako versus Thompson 263 US 197. So this is the definition of property. And then let's proceed to IP, or intellectual property. Intellectual property defined as any creation or product of human mind or intellect. Okay, this is a property. So the property can be tangible or intangible. And when we say intellectual property, it is intangible and it is a product of human mind and intellect. And we also have this IPR, or intellectual property rights. So the IPR are property rights which consist of copyright and related rights, trademarks and service marks, geographic indication, industrial design, patents, layout design, or topographies of integrated circuits, and protection on undisclosed information. It is according to Section 4 of Intellectual Property Rights, RA 8293. So these terms are relevant in order for us to fully understand about what is the intellectual property rights. Now again, we will have some of these very important question. What is the purpose, or what is the legal basis of these intellectual property rights? So it is in a constitutional basis according to Article 14, Section 13 of 1987 Constitution. So we can read on that Constitution, or Article number 14, Section 13 of this 1987 Constitution, that the state shall protect and secure the exclusive rights of its scientists, inventors, artists, and other gifted citizens to their intellectual property and creation. So particularly when beneficial to the people for such period as may have provided by the law. So the law provides a protection or a security of the exclusive rights of any scientists, inventors, artists, and other gifted citizens. Okay, so for example, you as a student, you can also have these rights, and also the teachers or any scientists or inventors or any gifted citizens. So it was provided by the Constitution. So intellectual property rights have these different um, parts here, as I mentioned a while ago. We have this patent, industrial design, this one, trademarks, or we have these trademarks and service marks, geographical indications, layout designs of intellectual circuits, and copyright and related rights. Now let's proceed to the nature of intellectual property rights. So there are four basic nature of intellectual property rights. Number one is the product of intellect. So the patent owners have the exclusive right to commercially make, sell, selling products, and also distribute and import and use their patented invention within the territory covered by the patent during the period of protection. So there is a time period of such protection. So you will renew your intellectual property because it will expire. And number two, there is a limited right, not inherent, territorial, and limited by time, as what I had mentioned a while ago. It was limited by time. So giving an exclusive right to the owner, most intellectual property rights cannot be implemented in practice as soon as the owner got exclusive rights. Number three, we have these business assets. The owner have the right to stop their competitors from using it during the patent period. So for example, you have this invention and then you found out that your competitors are using your intellectual property. So you have the rights to stop your competitors, okay, during that patent period. So you have this, we call it intellectual property rights. Number four, litigious, the subject to public policy. If someone else uses patented invention without the patent owner's permission, the patent owner can seek to enforce the rights by suing for patent infringement in the relevant national court. So you have this power. Okay, for example, your competitors will use your intellectual property without your permission. You have the rights to sue these competitors, and you can raise up into the national court. Now we will talk also. This is one of the important. There is also a product life cycle. So the product life cycle is the process the product goes through from when it is first introduced into the market until it declines or it removed from the market. So there are four stages here. The first one is the market development. At this time, this is the first stage of the product that your product will undergo. So there are some revisions, there are some improvement of your products, and it is really relevant as you sell your products in the market. And the second one is the market growth, in which it will attract more customers to purchase your products in the market. And then you have this stage three, the stage or the market maturity. This is the stage in which you will have in the peak level of the maturity of your products. Okay. And the fourth one is stage four. We have this market decline. So your product will no longer be attractive to your customers. That is why we can see different products in the market. They have these continuous revisions, enhancement of their products. Because if they will fail to develop or enhance their products, there's a big tendency that their products will decline. They will just renew. Just like for example in the juice, we can see that as of now we have different kinds of flavors, not like in the previous years. And also one of the example, the Kodak, they failed to enhance their products, so they have this market declination of their products. So it is important that we need to enhance or develop our products. That is why there's a limitation or just a period of time of having this intellectual property rights. Next, there are also reasons for intellectual property rights. First, it is the basic human rights according to Article 27 in the Universal Declaration of Human Rights. So the Article 27 says everyone has the right to freely participate in the cultural life of the community, to share scientific advances and its benefits, and to get credit for their own work. Also, the reason for IPR is the development of domestic and creative activity. And also, it facilitates transfer of technology and attracts foreign investments and ensures market access for national products. And lastly, it enhances economic, technological, and industrial country development. So it is advantage of having this IP protection. First, to the owner, because the owner will have these exclusive rights, as we mentioned a while ago, that they have the rights to sue their competitors if they are using your own intellectual property. And also, it has the strong market position, and you will have this higher return on investment. And also, we have this opportunity to license your intellectual property, and it also increase a negotiating power. And lastly, you will have this positive image for once in your own enterprise. You have this positive image. Now let's talk about also the advantage of having this IP protection to the society. So it is not only beneficial for the owner, but it also beneficial to the society. The first one is we have this better quality of people's life. For example, because of such inventions of many inventors and scientists, it creates a better quality of the community or society. Okay, for example, microwave oven, refrigerator, motorcycle. Okay, so it has this better quality of people's life. And also we have this protection from inferior quality of products. We can have this assurance that whatever we purchase in the market, they have this distinction of the quality of the products. And also has inputs and standards to industry on what products to produce and service to provide. So the question here also, so these are the advantages of having IP protection. The question also here is how to protect intellectual property. What we are going to do to protect our intellectual property. Again, these are the different intellectual property. We have this patent, industrial design, trade secrets, trademarks, service marks, geographic indications, layout designs of integrated circuits, copyright, and related rights. So we can protect this in a national level. We can protect also in a regional level and in even in international level of having this protection. So let's start first with the copyright. So what is a copyright? It is a legal protection extended to expression of ideas. Okay, it is a legal protection extended to expression of ideas. It includes literary, scholarly, scientific, and artistic creations or expressions, including computer programs. So we have this computer program, so that is part of the copyright. Okay, they have this copyright protection. Also the books, articles, even music, and also painting, sculpture, films, technical drawings, maps, and ads. So you can have that right, and we call it the copyright. So we also have the original and derivative works. And lastly, it is valid for lifetime of the author and 50 years beyond lifetime. Okay, 50 years beyond lifetime. Okay, it is valid for lifetime of the author. Okay, for having this copyright. So original works are the work created directly and personally by a particular person or artist, while derivative works are based on the original work of someone and imitation of others' work also. So a derivative work is one of that is constructed largely of a pre-existing work. Okay, so you just enhance. So the copyright protection is extends only to expressions and not to ideas. Okay, it's only for the expressions. Expressions of what? Expressions of ideas. Ideas and also procedures, methods of operation, or mathematical concept. So there are two types of rights under copyright. We have economic right and we also have moral right. So economic right allows the rights of owner to derive financial reward from the use of their works use others. And moral right which protect the non-economic, okay, which protects the non-economic interests of the author. So most copyright laws states that the right owner has the economic right to authorize or prevent certain uses in relation to a work or to receive remuneration for the use of their work. And also we have this, we call it the copy left because we have this copyright, we also have this copy left. It is a general method for making a creative work as freely available to be modified and requiring all modified and extended versions of the created work to be free as well. For example, here is the Wikipedia open source codes. So they provide these creative works and it is freely available to be modified, not like in the copyright. Now let's proceed to the trademark. We are done with the copyright and now let's proceed to the trademark. A trademark is any visible sign or mark capable of distinguishing the goods, trademark or service marks of an enterprise from another. It also establishes the goodwill of an enterprise by denoting the quality of its goods and services. And also, it includes a stamp or mark container of a goods. And lastly, it is valid for 10 years, but renewable as long as it is used. Again, for the trademark, it is valid only for 10 years, but it is renewable as long as it is used. But in the copyright, as we have discussed a while ago, it is a valid for a lifetime of the author, and also 50 years beyond the lifetime. Okay, but for the trademark, it is also valid for 10 years, but renewable as long as it is used. So what is the trademark? We also have these different brands and ranks, and there is a brand value of this. For example, the Facebook is exceeded into $500 billion in a market value as of July 27, 2017. And you can also check here the different brands. So now we will talk about the difference between trademark and registered mark. Okay, what's the difference between trademark and registered mark? The TM or the trademark symbol can generally be used by any person or business to indicate that a particular word, phrase, or logo is intended to serve as an identifier for the source of that product or service. So you do not have to have this registered a trademark. Registered a trademark to use it, and many companies will option to use the TM symbol for new goods or services in advance of and during the application process. So while the company have this during the application process of their new products, they will use this TM or trademark. Okay, and the registered mark is a symbol indicates that this word, phrase, or logo is a registered trademark for the product or service. It must only be used in the case of registered trademark and by the owner or licensee. It also must only be used in the regions in which you possess a valid trademark registration. So that's the difference between trademark and the registered mark. So now we'll proceed to the patent. So we're done discussing about the copyright and the trademark and the registered mark. What is the patent? Patent is any technical solution to a problem in any field of human activity. Also, it is an exclusive right granted by the government of a product or process which is novel, involve inventive steps, and industrial applicability. Also, it is being compared to the closest prior arts and apply for patent if the difference is not obvious, and it is valid for 20 years, non-renewable. It is only valid for 20 years. So the temporary monopoly granted to an inventor by the government in return for disclosing an invention. So the exclusive right to exploit the invention for 20 years from the filing date, that is to make, use, or sell or import an invention, that exclusivity right is territorial. Okay, so there is a territory or territorial. It's only for 20 years, non-renewable. So now let's discuss about the patentable inventions. Okay, we have some examples here, explanations here. A product such as machine, a device or article of manufacture, a composition matter, a microorganisms. And we have a process such as method of use, method of manufacturing, a non-biological process, a microbiological process. And we also have computer-related inventions. Invention involves a computer network, or other programmable apparatus, which features realized solely or partly by means of a computer program, and also an improvement of any of the foregoing. So these are the examples of patentable inventions. Product can patent the product, process, computer-related inventions, and improvement of any foregoing. We also have this non-patentable invention. What are the examples of non-patentable invention? Discovery, scientific theories, mathematical methods, a law of nature, scientific truth, or knowledge as such. Abstract ideas or theories, fundamental concepts, apart from means or processes for carrying the concept to produce technical effect. Schemes, rules, methods of performing mental acts and playing games. Methods of doing business, such as method or system for transacting business without the technical means for carrying out the method or system. And also programs for computers. Also methods for treatment of the human or animal body by surgery or therapy, and diagnostic methods practiced in the human or animal body. So this provision shall not apply to products and compositions for use in any of these methods. Also the plant varieties or animal breeds, or essentially biological process for the production of plants or animals. So this provision shall not apply to microorganisms and non-biological and microbiological processes. And also the aesthetic creations. And lastly, anything which is contrary to public order, health, welfare, or morality, or process for cloning or modifying the germline genetic identity of humans or animals, or uses of the human embryo. Now let's talk about this, um, the different areas of this patent, or the basic requirements of patentability. First, the said invention is not new if it is formed part of the prior arts, okay, or novelties according to sections 23 RA 8293. So what is prior art? The prior art refers to any information which has been made available to the public anywhere in the world. So before filing the date or the priority date of the application claiming the invention. So your invention or your patent must be novel or must be new. That is why it is important, as I mentioned a while ago, that we will have this um, overview of patent search. We will search the prior arts of our invention. Okay, so it is important that our invention must be novel or new. And also we have these inventive steps. An invention involves an inventive step. If having regard to prior art, it is not obvious to a person skilled in the art at the time of filing date or priority date of the application claiming the invention. Okay, so in the language of intellectual property practitioners, inventive steps refers to the quality of the developed technology which is not obvious to an ordinary person skilled in the art. So a person skilled in the art can be any lay person skilled in a pertinent technical field. Okay? And then the third one is the industrially applicable. Your invention must be industrially applicable. It is applicable in the industry. Okay, so an invention that can be produced and used in any industry shall be industrial applicable. So we have some example here. The UU toy. The inventor is Pedro Flores. So this toy has been mass produced by America and popularized all over the world. So the history of this yo-yo. The yo-yo was used by the Philippine natives 400 years ago as a combat weapon against the Spaniards and intruders. So this was invented by Pedro Flores, and it was mass have this mass production in America. Okay, and also we have this patis or fish sauce. So the inventor of this is Roberta David, aka Aling Tentay. A patis or fish sauce is a condiment that is used as a salty partner for any Filipino dishes. So Roberta David was responsible for its accidental discovery in 1949. Okay, so these are the examples of Filipino invention that is popular nowadays. And also the inventor of the medical incubator. The inventor is Miss Fidel Mundo. Fidel Mundo is the first Asian who was able to enter Harvard University School of Medicine. This improvised incubator comprised of two native laundry baskets. Okay, this is in improvised native laundry baskets that was placed one inside of the other. So the hot water bottles were arranged around and in between the two baskets to provide warmth, and it also include a market shift hood over the overlapping basket so that the oxygen will be able to circulate within. So this was created in order to address the needs of families in rural areas that have no electricity that is needed to regulate the body temperature of the newborn baby. So this is a invention of Fidel Mundo, a medical incubator. And we have this inventor Abelarda Aguilar, erythromycin. Okay, it is an antibiotic that is derived from the bacterium Streptomyces, I don't know how to pronounce this one, which normally used as an anti-acne or remove pimples. So it is a Ilonggo doctor or scientist, Abelardo Aguilar, discovered that this strain in 1949 using the soil in his home province. Unfortunately, when he sent it to his United States employer in Elililico to separate the said strain, the Indiana-based company owned the drug, and Aguilar was not given any credit for this discovery. That is also a bad situation here. That is why it is very important that if we will discover something, we'll have this intellectual property rights. We will apply for it. And we also have this utility model. So we are done with the patent. And now let's proceed to utility model. Any machine, tool, implement, products or process that is new and industrial applicable. Utility model also, unlike in an invention, it doesn't require substantive examination. So if you have this utility model, you no longer have this part of the process which is the substantive examination. And also known, the utility model, also known in other countries as petty patent, valid only or until 7 years only. Okay, that is why there are many inventions. We will apply for a patent, and if it is really hard to pass this different examination, we will proceed to utility model. But it is only valid until 7 years. We have some example here. We have this hand-driven motorcycle for wheelchair. Okay, and we also have these different kinds of wheelchair, rehabilitation wheelchair. Okay, so as you can see here, there are different numbers here. So in our papers, or in our documents, we will discuss these different parts. What are the functions? What are the materials used in these different parts? Okay, so later on in the um, other trainings or seminars, we will discuss this in a detail. So as of now, we will just talk about the overview. Now let's proceed to the intellectual industry design or ID. Industrial design is any composition of lines or colors or any three-dimensional form, whether or not associated with lines or colors. Industrial design also gives special appearance and can serve as a pattern for an industrial product or handicrafts aesthetics aspects of an article of manufacture. And also it has the 5 years from the filing date of the application. May be renewed for not more than two consecutive 5 years each by paying the renewal fee. So you can renew this industrial design. You'll just pay for a renewal fee. So we have some example a industrial design here. We have this Yoda chair and we have an chair and also Alici Juicy Salif. This is an example of a industrial design. And there are also other forms of intellectual property through plant variety protection. So a one-of-a-kind system that gives right to breeders or farmers over the varieties they breed or discovered and develop. Also, exclusive right to produce, offer for sale, or market propagating materials, and also have known as a plant breeder's right. So there are different varieties. We have this new, distinct, uniform, and stable. True undisclosed information or trade secret. Any information with commercial value withheld by a person or entity subject to reasonable steps to keep it from unauthorized access. And we also have decoded through know-how, the information, practical knowledge, techniques, and skill required to achieve some practical and especially in industry or technology. Know-how is considered an intangible property in which rights may be bought and sold, according to Black's Law Dictionary in 2009. And we also have this through indigenous people's right. It is refers to community intellectual right of the indigenous cultural communities, indigenous people, as provided for under Section 32 of RA 8371. So in summary, we have these different facets of intellectual property. We have patent, utility model, trademark, copyright, industrial design, graphical indications, layout design of integrated circuit, and we also have the trademark. So what is protected in our patent? We protect the products and the process for the patent. In utility model, we protect the improvements. And for the trademark, we protect the business identities of our business. And for the copyright, we protect the original works of authorships. And for industrial design, we protect the aesthetic features of a product. And for graphical indication, we protect the products originating in an area. And for the layout design of the integrated circuit, we protect the topography or spatial arrangement elements of integrated circuits. And for the trademark, we protect the business secrets. For example, the ingredients of soft drinks Coca-Cola. And for the patent, for us for registration, we will go to the IPOPHL, same with the utility model, trademark, and industrial design, graphic indication, and layout design of integrated circuit. So the trademark will no longer need to register. And for the copyright, we can register to IPOPHL and also National Library. As to test, for the patent, we will test the novelty, non-obvious, industrial applicability. Same with the utility model. And for the trademark, doesn't duplicate existing mark. So the important here that there is no existing mark. And for the test for the copyright, it must be original. And also the industrial design, same with the trademark. It doesn't duplicate existing design. So it must be unique. And for graphical indication, product should originate in geographical area. And also in the layout design of integrated circuit, same also, doesn't duplicate existing design or arrangement. And for the trade secrets, it no needs to test. So we can see here, as we can see here, it's really hard part of the one of the hardest facets of intellectual property is the patent. And also here, how to obtain for the patent, it needs to have this registration. Okay, same all of these different patents, facets of intellectual property. And this is also one of the very important information that you need to know. For the patent, according to as to duration, for the patent it is 20 years from filing date. So after 20 years, it will expire. For the utility model, it is only 7 years from the filing date. Okay, so as we can see here, this patent is the hardest to have of your any invention, the patent. As to trademark, the 10 years and renewable every 10 years as long as it is used. For the copyright, it is a lifetime with the author or inventor plus 50 years after death. Okay, so you can still protect your copyright even you are already dead, and we have this plus 50 years. For industrial design, it is only 5 years, but it is a renewable for none more than 2 consecutive 5-year terms for a total of 15 years. Okay, it is 5 years and you can renew 3 times. So the total of 15 years. Okay, 5 years renewable for not more than 2 consecutive 5 years terms for a total of 15 years. And for graphical indication, as of now, 10 years. For the layout design, 10 years. And for the trade secrets, as long as it is remained as secret. So we are in the last slide. So it is really important reminders here. Protect first before disclosing. Okay, so just recap here. You have this patent search. You will search your idea of your possible invention. Okay, that is coming from your idea. You will search on that. And you have plus non-disclosure agreements. And you have this, you will test your invention. Then you will proceed to products or process. It may be product or it may be a process. And you will apply for protection. All of your, for example, if you are in the patent, utility model, copyright, trademark, industrial design, okay, you will register your invention. You need to protect your intellectual property. And lastly, public disclosure and commercialize. There are many people now who are very rich because of their invention. They have this, we call it a passive income, because they have this, they receive a percentage. For example, if we, for example, as a student or a teacher, if we have this invention and we present it to the business owner, so they have this, for example, after you present this invention to the business owner, they have this, they like your products or they like your invention, and they will mass produce your invention. And if there are many customers would like to buy these products, you will have this share, you have this percentage, and you have this passive income. So there are many people now who are very rich because of their invention, but it needs to be protected. So once again, thank you for having me. And later on, we will have this demonstration on the overview of patent search, which is the first step. Thank you.